Let's listen to Pavarotti.
Hello, welcome to The Revealing. I'm your host, Pavarotti, here to discuss the Idaho 4 case. As a disclaimer, this channel is for entertainment purposes. These are my opinions. I'm not here to slander. Let's get into it. I'm going to provide information and give you my opinion. Now, first of all, I had a little early Thanksgiving today, so I am full as a tick. Nobody makes Thanksgiving turkey like Pop's mom. Boy, she was awesome. Spent a little time with the family. It was just a really good day. And we've got more documents in the Kohberger case. I want to cover those for you because a couple of them go along with the documents that I went over with you the other day. And we've got an order from the court. We've got an objection from the defense. And we've got another order for the court on the Franks hearing, but it's an order to be more specific, and we'll cover that. But there's something in that order that shows us some real information and verifies what we've been thinking. And I've got some other information that will coincide with that I'll be putting out here soon. But let's just get right into it. So I showed you a couple of days ago the motion that the prosecution filed in order to get a different assistant attorneys general, and I explained the repercussions of that Thompson was scared to death and they were trying to bring in some guns. Well, the judge ordered in their favor immediately, says the above matter coming before the court, it is hereby ordered that the Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorneys General to assist in the prosecution of this case. Now, this broad language here, Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office. This has sent the defense in an uproar. So they've already filed a motion of objection. They've already objected to it, even though the judge already, ordered it. They've promptly objected to it. Let's take a look at it. Okay. So we talked about the motion that the prosecution had filed for Special Assistant Attorneys General. And the court actually granted that motion for them. But now we got the defense firing back. Objection to court's order for the special appointment of Special Assistant Attorneys General and decision without hearing. So good for them. The grounds for this objection are that the state has not articulated good cause for the appointment. Idaho Code does not authorize multiple attorneys general. Mr. Kohberger will be denied the right to a fair trial if the state is given the broad authority to appoint multiple special assistant attorney generals without any specification of who and how many. The plain language of the statute, upon a finding of good cause for an assistant attorney general to assist in the prosecution, the state's petition seeks to give Idaho's Criminal Law Division of the Attorney General's Office the broad discretion to appoint as many designees as it sees fit. So they could, with that broad order, they could, get a team of people over there that Johnny Cochran couldn't battle. The authority sought in the proposed court order is that the Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorneys General to assist in the prosecution of this case. This language, when coupled with the explanation in the petition and the letter that accompanied the petition, is to grant Mr. Nye or his designee carte blanche authority to choose assigned Deputy Attorneys General, as many as be appropriate. The authority sought in the petition and draft order is without any rationale for good cause and is beyond the scope of the authority set forth in the statute for attorney. This is different than what the state did earlier in this case. When the state first sought the appointment of the Idaho Attorney General's office, In April of 2023, the petition set forth 2 specific names. The time for Mr. Kohberger to object is now, because Idaho case law indicates that once a special assistant attorney is appointed, there is no collateral attack available absent a showing of an unfair trial. It's important Mr. Kohberger have knowledge of what prosecutors are acting on behalf of the state to preserve all issues associated with a fair trial. This is not a routine matter, as asserted by the state. This case is a very high-profile case, and as such, the court has taken many measures to protect sensitive information. These measures include a non-dissemination order, sealed filings, and protective orders. The case has a huge amount of discovery. Look at here, now over 60 terabytes of information. It is critical to the preservation of the confidential nature of this case that this court and the defense know who has access to the case files and who's acting on behalf of the state as prosecutor. As such, counsel for Mr. Kohberger took the prosecutor up on his offer in the letter to the court and emailed with a request for clarification relating to the requested broad authority for Mr. Nye. No answer came. They didn't bother answering her back. Upon showing a good cause and a finding of good cause, the court should limit the appointment of the Special Assistant Attorney General to a single attorney, or at bare minimum to a specifically named prosecutor. Under a plain reading of the statute, there's no statutory authority for more than one attorney or broad discretion of an open appointment to an entire Attorney General's office. A hearing is requested on this matter, and as it is not a routine matter to give an entire legal division of the Idaho Attorney General's office authority over who appoints as prosecutors in this case. So basically the judge gave them a blanket order of approval, and based on that, the prosecution could put a 16 team of attorneys over there to prosecute Kohberger. And that's exactly what they had in mind. You can bet that little things like this aren't done for no reason. So they were trying to stack the deck because they are very, very nervous. And we'll see that in the next doc that I'm going to show you. All right, now we've got an order already. I mean, Hippler is on making these decisions. This was for that bogus... And now that I really look at this, if you watched my video the other day on these bogus, trying to keep the memorandum pages to less than 15 because of a local 4th Judicial District rule. And he cited 8.1 and 8.3, but then he kept putting 5.3 in there, which confused me because there wasn't a 5.3, but it turns out it was an error. It was supposed to be just 8.1 and 8.3. But you can see right here that it says, before the court is the state's motion to strike defendant's memorandum in support of motion to suppress, and it's the genetic information and the memorandum in support of the Franks hearing. The state aptly points out, he's giving them credit, that both memoranda violate Rule 8.1 of the 4th Judicial District local rules, setting a 15-page limit on memoranda in support of non-dispositive motions. Defendant's memoranda at issue are 37 and 33 pages respectively. Moreover, defendant did not seek leave of court to file overlength memoranda, which is contemplated by local Rule 8.3. Yeah, it's funny though, is he didn't cite that he's calling out rules in the 4th Judicial District and he's in the 2nd Judicial District. What do you got to say about that there, Hippler? Given the breadth and significance of the two motions at issue, the court declines to strike the memoranda. So, in favor of the defense. Had defendant moved for leave to file overlength briefs, it would have been granted. The court will, however, allow the state an equal number of pages in its filing in responses to the two motions. In the future, counsel shall abide by the page limit set by the local rules or seek leave of court in advance of filing an overlength brief. So he's saying he would have given them the leave. He's ruling in their favor. In the future, if it's going to be more than the page limit page limits, then all they have to do is get with the court first and let them know that's going to be more than the maximum page limits, and he'll grant it for them. So that was a kind of a positive for the defense there. Finally ruled something in their favor. But this is the one that is really going to give us some insight into this case. And I don't know if they meant to do it or not, but it sure is going to give it to us. They probably thought people wouldn't pay this close attention. But this is the judge's order for the Franks motion. And before the court is the defendant's motion for Franks hearing and memorandum in support of motion for Franks hearing. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. Thus, the court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. So, basically, in their 37 or 38 page motions, their exhibits, they comprise of over 2,000 pages. So their memorandums are over 2,000 pages because of the exhibits. So the memorandum's only 37 pages, but the 38 exhibits that they added to it were over 2,000 pages. And you see, this is what the defense has been dealing with ever since the beginning. They get this massive pile of discovery. Nothing's in order. They have to sift through it, like, picking needles out of haystacks. So they turn over an exhibit that's much in the same way, and the judge looks at it and goes, God, I got to go through all this and try to figure it out. No, this is too much information. The court is not required to search the record looking for evidence. We're not required to search it looking for evidence. Well, the defense is probably not really required to search it looking for evidence either, but they did. He even cited case law, Venable versus Internet Auto Rent and Sales. This judge is something else. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number. Look, he's giving them a way for him to go through and actually find the stuff. And line number if referring to testimony for the facts asserted. In addition, defendant must resubmit his supporting exhibits to exclude portions that are not relevant to the motion. Because the state is under a deadline to respond, the court will allow defendant until Tuesday, November 26th. Yeah, redo the whole freaking thing by Tuesday to submit the revised filings. But, well, man, I hope Ann Taylor and team did not have anything planned for this weekend, because I'm sure they'll be putting in 23-hour days to get that done. But here is the thing that's going to give us so much insight into the defense's strategy, and all it does is reaffirm everything that we have said for a long time, and I'm loving it. Look at this little thing here. By way of example, defendant cites generally to Exhibit D9 for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. That exhibit is over 100 pages of duplicative emails. Defendant does not identify which email supports his proposition. The court will not do counsel's job and scour the exhibit to decide what portions defendant must be suggesting supports his assertion. So, if you remember, he's talking about the 2011 to 2013 Elantra and the expert identifying it as that. In court, when she put Brett Payne on the stand, and she got him to admit that he didn't talk to the WSU officer until December 20th, not November 29th. She also referenced an email exchange, and she pressed him for the date that the expert changed his opinion of the year models of the Elantra. So you can bet what she is showing in the exhibit is the expert identified it as an 11 to 13 until Kohberger's name was put in. They got the video from WSU of the 2015 Hyundai Elantra, and then based on that, he extended it from 2011 to 2016, and she's got the email chain between the investigators to prove it. So the judge is saying, I'm not going to read 50 pages of these emails, just circle the emails that prove your point. Hopefully they can get that done and do that. But that is freaking huge, and I'm going to have a video for you probably tomorrow as we're going to dive into that Elantra, because the first 3 passes of that Elantra in that neighborhood, I believe, is a white Hyundai Elantra. And I believe it's a 2011 to 2013. I believe it's the one up in Eugene, Oregon they found. And I'm going to give you some information that will tie it to the perpetrators in the case, and you will probably freak out. So that's the filings. Things are really, really interesting right now. So there you have it. The Franks motion is still in play. The defense, I hope they're working their tails off this weekend to make sure that everything's is like that judge asked it to be. And keep firing, because he's fast. He's fast on these orders. They're not particularly in the defense's favor so far, but he's fast. But I got some information about the Hyundai Elantra, and I'm kind of giddy wanting to get it to you, so I'll get it to you soon. But please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.